A date has been set for a Crown appeal against the manslaughter sentence handed to a former New South Wales police officer who avoided jail after he tasered a 95-year-old great-grandmother in her nursing home. Prosecutors will argue Kristian White's sentence was manifestly inadequate as part of 4 grounds of appeal. Court reporter Jamie McKinnell joins me for more now. Jamie, what have we learnt about this appeal today?
Well, we know now that this will be a very short appeal. It's only going to take a couple of hours and it's going to be heard on June 27. Now, Kristian White was handed a 2-year good behaviour bond a couple of months ago after he was found guilty by a jury of manslaughter. A part of his sentence was also 425 hours of community service. But this appeal is sort of the reverse situation to what people might be familiar with. Usually, if an offender gets a jail sentence, they might appeal to overturn that sentence or at least make it shorter. This is a situation where a person has not gone to jail at all, avoided a custodial term, and it is the DPP arguing that was the wrong outcome. Now, Kristian White was called to Yallambee Lodge in Cooma in May 2023, where 95-year-old Clare Nowland had been wandering around with 2 knives. He was there with paramedics. There was a standoff and Mrs. Nowland was told to drop a knife a number of times over several minutes, but eventually Kristian White said, "Nah, bugger it," and used his taser on her, causing her to fall backwards, and she died about a week later. Now, Justice Ian Harrison in the New South Wales Supreme Court, when he sentenced Kristian White, found that this former police officer made a terrible mistake. The judge said Kristian White misread and misunderstood the dynamics of the situation, but he also found that White was motivated by an honestly held but mistaken and unreasonable belief about the nature of the threat that was posed. And the judge said this was a situation which never called for such a response. The judge also found that this was a crime that fell on the lower end of objective seriousness, and he found that in terms of general deterrence towards police officers who might find themselves in similar circumstances, the general deterrence played a minor role in this sentencing exercise. Now, for the Nowland family, this was a very shocking outcome. They've described it as a slap on the wrist. Today, this appeal was in court for a pretty brief and procedural mention, and the registrar acknowledged that the main question here is whether or not Kristian White will be put into custody. The registrar said that he was mindful that that would be weighing on Kristian White, and that was part of the reason why this is all happening quite quickly, and the appeal will happen within months.
And there are some other grounds of appeal as well?
Yeah, that's right. So the DPP has 4 grounds of appeal. One of them is about the judge's assessment of the objective seriousness being on the lower end of that scale. They're arguing that that was a legal error, and there are other legal errors that they've picked out as well, which they will argue. Another one will be about the finding about general deterrence playing a minor role in terms of towards police officers that I mentioned. And overall, they're going to argue that this sentence as a whole was manifestly inadequate. So the grounds of appeal give us an idea about the topics that might be covered, but appeals are very legally technical in nature. So we're going to have to wait and see how this plays out and whether the result for Kristian White will change.
And so we'll be speaking to you again around that time. Thanks very much, Jamie.